In the recent case, Chiles versus Salazar, the Supreme Court was asked if Colorado's conversion therapy law violated Mrs. Chiles' right to free speech. As is often the case, the court agreed that the law violated Mrs. Chiles' free speech rights just for the wrong reasons. So we'll discuss that next on the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach your and generation be free. Glad you could join me today. I've covered the oral arguments in a previous episode of the Constitution Study. So if you want, you can find it on the website, constitutionstudy.com. Today, I'm looking at the opinion of the Supreme Court, and I'm going to break it down to what I think are the most important points of that. Again, if you want to find the other article, you want to follow along with what I'm doing, go to constitutionstudy.com. Find the article. I have links to all my sources, and you can follow along and double check my work. I'll talk more about the website and ways you can support the work we're doing at the end of the episode. But for now, let's get into this case, Chiles versus Salazar. This all started with a 2019 Colorado law banning what some people called conversion therapy for minors. From the opinion we read, in 2019, Colorado adopted a law prohibiting licensed counselors from engaging in, quote, conversion therapy, close quote, with minors, defining the term to include any practice or treatment that attempts to change an individual's sexual orientation or gender identity, as well as any effort to change behaviors or gender expression, or to eliminate or reduce sexual or romantic attraction toward individuals of the same sex. Now, Colorado defines conversion therapy as any attempt to change or convert a person's behavior, gender expression, or sexual attraction, but only to those of the same sex and so-called transgender. This is a one-sided and biased law. Yet the law explicitly allows counselors to provide acceptance, support, and understanding for identity exploration and development, and to assist persons undergoing gender transition. So Colorado thinks it's okay to encourage such attraction, but not to discourage it. Now, part of the push behind these conversion therapy bans has more to do with the imagery rather than the actual techniques. The term conversion therapy may evoke physical techniques such as electric shock therapy aimed at changing an individual's sexual orientation or gender identity. Now, Colorado's law doesn't simply forbid shock therapy or any other therapy that harms the individual. The law forbids as well any effort to change behaviors or gender expression or to eliminate or reduce sexual or romantic attraction or feelings toward individuals of the same sex. At the same time, the law explicitly allows counselors to engage in practices that provide acceptance, support, and understanding for the facilitation of an individual's identity exploration and development. Likewise, the law allows counselors to provide assistance to a person undergoing gender transition. So, Colorado doesn't have an issue with conversion therapy, only in attempts to assist those who are not comfortable with their homosexual or transgender feelings. In other words, only those that challenge the politically correct idea that homosexuality and transgenderism are normal. Ms. Chiles filed suit in federal court seeking a preliminary injunction raising a First Amendment challenge to the law as it applied to her talk therapy. Now, Ms. Chiles claims that the Colorado law violates her rights protected by the First Amendment. I will discuss the First Amendment issue in another section where I will show this is actually a 14th Amendment violation. However, the question the court was asked specified a violation of the First Amendment. The question before us is a narrow one. Ms. Chiles does not question that Colorado's law banning conversion therapy has some constitutionally sound applications. She does not take issue with the state's effort to prohibit what she herself calls long-abandoned adverse physical interventions. Instead, Ms. Chiles stresses that she provides only talk therapy, employing no physical techniques or medications. Ms. Chiles agrees some form of conversion therapy, namely those with adverse physical interventions, can be banned. However, she does not employ such physical techniques or medication, yet Colorado's law still applies to her. Yet she agrees Colorado's law still applies to her, prescribing what she may say in voluntary counseling conversations with her clients. And because that application of the law strikes at the heart of First Amendment protections for free speech, she contends it warrants considerably more searching scrutiny than the rational basis review the 10th Circuit applied in this case, or the immediate scrutiny review some other lower courts have employed in cases like hers. We agree. I agree that Colorado's law abridges Ms. Chiles' freedom of speech and much, much more. However, it does not and cannot violate the First Amendment. Justice Gorsuch delivered the court's opinion, joined by Justices Roberts, Thomas, Alito, Sotomayor, Kagan, Kavanaugh, and Barrett. Both the District Court and the Tenth Circuit determined that Ms. Chiles had an Article III standing to pursue her as-applied pre-enforcement challenge. On the merits, however, both courts denied Ms. Chiles' request for a preliminary injunction, reasoning that Colorado's law is best understood as regulating professional conduct and that it regulates speech only incidental, thus triggering no more than rational basis review under the First Amendment. This court granted certiorari to resolve a circuit conflict over how the First Amendment interacts with laws like Colorado's when those laws are applied to talk therapy. Now, both the district and certain courts said that Ms. Chiles had standing to sue, even though Colorado had not yet enforced this conversion therapy law against her. They also said this law primarily regulated professional conduct. However, that does not allow the state to violate the Constitution of the United States, and specifically the Supremacy Clause, which reads, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding." Yes, the Constitution does not prohibit states from regulating professional conduct, but it does prohibit depriving people of their liberty without due process of law. Now let's talk about this First Amendment issue. From the opinion we read, "The First Amendment protects the inalienable right of every individual to decide for himself how best to speak." That's from Riley versus National Federation of the Blind. And laws regulating speech based on its subject matter or communicative content are presumptively unconstitutional, triggering strict scrutiny that requires the government to prove its restriction is narrowly tailored to serve compelling state interests. Viewpoint discrimination represents an even more egregious form of content regulation from which governments must nearly always abstain. Now, most everything Justice Gorsuch said was true, except for the statement about the First Amendment. Now, while freedom of speech does protect a right for people to decide for themselves how best to speak, First Amendment protections are limited. Did you notice how the court did not quote the First Amendment but previous court opinions? Maybe because that would prove the error of their statement. The First Amendment reads, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech." Since Congress did not make this law, it cannot violate the First Amendment. We do not doubt that the question how best to help minors struggling with issues of gender identity or sexual orientation is presently a subject of fierce public debate. But Colorado's law addressing such conversion therapy does not just ban physical interventions. In cases like this, it censors speech based on viewpoint. Yes, Colorado's law censors speech, and only for one viewpoint. That does not make it a First Amendment violation, though, but a free speech violation. Now, substitute free speech to the First Amendment, and the next statement makes a lot more sense. Colorado may regard its policies essential to public health and safety. Certainly, censorious governments throughout history have believed the same, but the First Amendment stands as a shield against any effort to enforce orthodoxy in thought or speech in this country. It reflects instead a judgment that every American possesses an inalienable right to think and speak freely, and a faith in the free marketplace of ideas as the best means for discovering truth. However well-intentioned, any law that suppresses speech based on viewpoint represents an egregious assault on both of those commitments. Very interesting point, because Colorado is not the only government that has attempted to censor speech it disagreed with. That puts Colorado on the same footing as every other despotic, censorious government that has ever risen. Now, I was rather surprised that 8 of the 9 justices supported free speech. Justice Kagan wrote a concurring opinion, which Justice Sotomayor joined. In that concurring opinion, Justice Kagan brought up an interesting point. The court today decides that the Colorado law challenged here, as applied to talk therapy, conflicts with core First Amendment principles because it regulates speech based on viewpoint. I agree. I write only to note that if Colorado had instead enacted a content-based but viewpoint-neutral law, it would raise a different and more difficult question. What if Colorado had written their law prohibiting any form of conversion therapy? What if those who promoted homosexuality and transgenderism were held to the same standards as those who opposed them? Justices Kagan and Sotomayor may tend to hold a viewpoint-neutral censorship law constitutional, But that would disagree with the Constitution itself, because freedom of speech isn't limited to so-called viewpoint-neutral content. It protects all forms of speech. Justice Jackson was the lone dissenter to this opinion. There is no right to practice medicine which is not subordinate to the police powers of the state. This was true 100 years ago, and it should be true today. Even the police powers of the state are subject to their constitutions and the Constitution of the United States. Many states may have chosen to exercise their police powers to ban conversion therapy based on the medical profession's broad consensus that this is medical treatment, which seeks to change a person's gay or transgender person's sexual orientation or gender identity, is ineffective and harmful. Rights are not determined by consensus. Obviously, there are medical professionals who disagree that attempting to help someone reverse unwanted attractions are dangerous. While the guilds that control the medical professions may claim these treatments are harmful, not all of those they claim to support that actually agree with them. We're not talking about group rights, but individual rights. When the majority can overrule the rights of the individual, we are the exact despotic democracy our founding fathers worked hard to ensure we would not become. This case involves the Colorado legislature's policy decision to prohibit licensed medical professionals from offering or providing conversion therapy to minors in that state. Except it does not prohibit medical professionals from offering conversion therapy, but as I've already shown, only conversion in one direction. So I respectfully dissent. Stated simply, the majority has failed to appreciate the crucial context in which Chiles' constitutional claims have arisen. Chiles is not speaking in the ether. She is providing therapy to minors as a licensed healthcare professional. The 10th Circuit was correct to observe that there is a long-established history of states regulating healthcare professions. And until today, the First Amendment has not blocked their way, for good reasons. Under our precedent, bedrock First Amendment principles have far less salience when the speakers are medical professionals and their treatment related to speech is being restricted incidental to the state's regulation of provision of medical care. Except the justices seem to have forgotten the very reason we establish governments, to secure our rights. When the government becomes destructive of our rights, it is our right and duty to alter or abolish it. Chiles insists that although she is a counselor licensed by Colorado, she has a constitutional right to flout Colorado's statute and the standard of care it incorporates if a client asks her to do so. Apparently, Justice Jackson has forgotten that Colorado does not have the right to deprive their citizens, even licensed professionals, of their rights in order to promote their political agenda. Ms. Chiles has the right to flout Colorado's laws when they violate the supreme law of the land. So what can we conclude from this opinion? Colorado's law banning conversion therapy as applied to Ms. Chiles' talk therapy regulates speech based on viewpoint, and the lower courts erred by failing to apply sufficiently rigorous First Amendment scrutiny. I agree with everything the court found except for the First Amendment basis. Colorado's law regulates not only speech, but liberty itself, which does violate the 14th Amendment, which reads, "Nor shall any state deprive any person of life, liberty, or property without due process of law." This law not only denies Ms. Chiles of the liberty to provide guidance as she sees fit, but it deprives those who want this type of therapy the liberty of seeking it, all without due process of law. Not only does this make this a 14th Amendment violation, not a first, but it greatly expands the scope of the violation. As I've pointed out, this law violates rights not only of Ms. Chiles, but of any medical professional that wishes to help people with unwanted feelings or sexual attraction. It also violates the rights of minors and their parents to seek assistance in dealing with unwanted attractions. Furthermore, these restrictions are not based on due process. It's not designed to protect the rights of the individual. Neither does it protect people from harm. This law is solely about promoting a political agenda designed to elevate homosexuals and those claiming to be transgender to higher rights than the rest of us. And if that isn't a violation of due process, I don't know what is. So once again, the courts come to the right conclusion, but for the wrong reason. This is becoming a habit. That's why I keep saying the 9 people most in need of a reading comprehension program are the justices of the Supreme Court. So we should be thankful that they came to the right conclusion. My concern is that if it's not based on the right reason, there's nothing really to stop them from coming to the wrong conclusion next time. Just look at the concurrence that Justice Kagan wrote, saying, well, listen, if you just reworded this law a little bit, we'd have a harder time fighting against you. Yeah. Now, again, you want to find out more, I put all the content and all the articles on the website, constitutionstudy.com. You can follow all my links and follow along. I think it's important. It's important that you not simply take this because Paul said it, but because I have evidence and I brought facts and data that you can trust but verify. Again, find out more. Go to the website constitutionstudy.com. You can join our mailing list. You can be notified when I get new videos or when I post news items or whatever. You could also support the work that we're doing here. Now, the easiest way is to go to the store, constitutionstudy.com/shop, and buy something. A book, a mug, a t-shirt, anything you buy, all the money, all the profits go to supporting the work that we're doing here, not only to help me bring you these episodes, but to help me do speaking events at other locations without charging them. Again, constitutionstudy.com/shop is a place you can go. You can just donate to the cause there if you'd like and make a one-time or recurring donation. You can also support us with your cell phone. Patriot Mobile is America's only Christian conservative wireless provider. They provide great 4G and 5G service. They provide 100% US-based customer support, and they got pretty good prices too. But best of all, they take a portion of every dollar they make to support organizations like the Constitution Study that are fighting to defend your rights. Just go to patriotmobile.com/constitution and find a plan that works for you. Check to see if you're eligible for a discount. Everyone from veterans and first responders to families with multiple lines are eligible for discounts. And use the code Constitution at checkout to get your line activated absolutely free. Not a bad deal. Again, go to patriotmobile.com/constitution, find a plan and discount that works for you. Use the code Constitution at checkout to get free activation. Of course, I also hope you come back and join us here and maybe bring a friend or two the next time we meet for the Constitution Study.